Anyway, on to our talk for today, at which point I will hand over to our panel. I believe, Roger, you're going to take the reins first, so I'll hand over to you.
Thank you very much. So let's start with some introductions. So for those of you who don't know me, my name's Roger Isaacs, and I am the forensic partner at Milsted Langdon. So I'm definitely the bad in when good deals go bad. So I deal with these cases when everything has gone horribly wrong. And this talk is all about trying to make sure that for those who draft agreements, it remains good, that there aren't any disputes. And that is why I'm delighted to be joined by two of my colleagues from Harbourside Corporate Finance, which is part of Milsted Langdon. Hollie and Alex do the lead advisory and due diligence work, as well as valuations that precedes any transaction. And it's only in the cases that go horribly wrong that I get involved. So really what we're going to be focusing on today is what you guys should put in sale and purchase agreements, because that really is where, for today's purposes, the story begins. So what we're going to do is we're going to start off by looking at the relevant sections of the SPA that tend to lead to expert determinations, and then to consider the issues that you should bear in mind to make sure that you never have to appoint an expert to determine any issues, because everything is so clear, unambiguous and straightforward in the terms of the drafting of the SPA that there is no room for any argument. So what I'm going to do to start with is to hand over to Hollie and Alex to talk about some of the number related elements of the SPA, what they mean and why we're going to be talking about them in a bit more detail in the context of expert determinations in a bit. So over to you, Hollie.
Yeah, so we'll briefly look at both the completion accounts mechanism and the locked box mechanism. So the completion accounts mechanism is where we see most disputes, because there can be significant post-completion price adjustments. So absolute clarity on accounting policies in this area is essential. So the hierarchy in the SPA that we usually deal with is firstly that they're prepared in line with specific accounting policies. Secondly, in line with past practice and on a consistent basis, which of course is a vendor's preferred way of doing it. And then thirdly, on generally accepted accounting principles. Now, on that third one, it's just worth noting that there is some judgment within those generally accepted accounting principles. So it may be the case that specific accounting policies are needed to be clear about what those judgments should be in this specific scenario. So where the time investment is really required is in those specific accounting policies, and the vendor understanding exactly why they are in there and what the implications are of those on value. And actually the flow of those and being clear on order and precedence, we do see SPAs where on the face of it, it looks clear. When you get into the detail and the detail of a dispute, actually there is ambiguity in there. Alex, did you want to add anything?
I would just to, double down on what Hollie just mentioned about the clear and unambiguous nature of the impact on value for vendors. I think the disputes are most likely to happen where a vendor wouldn't get the value that they were expecting, or a buyer was paying more value than they were expecting. And to the extent that that can be cleared as much as possible prior to completion is always going to ease the transition post completion.
And it's often assumed that the accounts have been prepared correctly in accordance with generally accepted accounting principles. Now, hopefully by this point, the due diligence will have picked up if there's an issue or an error, but that's not always the case. And it may be worth explicitly saying in there that if there is an error in the way they've been generally accepted accounting principles have been applied, or they've been applied incorrectly, and setting an order of precedence in there on that point as well. So moving on to locked box then. So locked box fixes a purchase price at a set date. So it reduces you have no need for these post-completion price adjustments. Now, this usually happens in the case where there's a stable business, working capital, where the buyer is very confident about the historical results, and that the balance sheet value won't significantly shift between the locked box dates and completion. Now, where there is scope for dispute is leakage. Now, what leakage means is leakage of value. So it means that where the vendors extract value which they should not extract. So we have both permitted leakage and where there's areas where there can be no leakage. So in the schedule of permitted leakage, we want to be explicitly clear about where there can be leakage. So it might be there's existing obligations that they have to meet, so payment of market rate salaries and bonuses and agreed dividends, but actually narrowing it down and being specific about those, quantifying them and having a cap on them is important in those locked box deals. Now, moving on to net cash and net debt, and I'll ask Alex to add to this as well. It sounds quite straightforward, doesn't it? Net cash and net debt. We know what we mean by cash and we know what we mean by debt, but do we really? Defining debt, there can be quite a wide definition of debt. So behind each of those debt and cash figures, having a very detailed schedule of every figure and every item that contributes to that figure, and that will then be a moving feast throughout the transaction, so that it's understood what impact every adjustment has on the overall net cash or net debt figure and the adjustment to value overall. Alex, did you want to add to that?
Yeah, I think any buyer during due diligence will, whoever's doing their diligence for them, whether it's themselves or having an advisor doing it for them, they should put together a schedule of net cash and working capital and go through the balance sheet and allocate each balance sheet item between working capital, net cash or debt or other. And while it can be a question as to what can be shared with the vendors, then it is usually a good idea to show that to them quite early on and give them the option of, to the extent that they want to, playing around with the figures to understand how each line item would impact value. There are some items that are just, they are very clearly defined within cash or debt or working capital. But, for a vendor to actually understand what the impact on their value is for an allocation between these elements, then it can be quite a useful procedure prior to completion to helping a vendor actually understand what cash is going to be due to them at or post completion.
And then on working capital as adjusting item. So the target working capital will be agreed in the SPA. Of the buyer will normally look at working capital over a 12-month period, possibly longer, to determine what they think is the normal level of working capital. And again, with both those items, the debt and cash adjustments and the working capital adjustments, the timing can be quite critical and can impact significantly on value. So just with being aware of the timing of the transaction and the vendor, and the buyer, obviously they both want the best value. The vendor wants the highest price and the buyer wants the lowest price. So yeah, the push and pull of those two can make a big impact. And if there's a lack of clarity about how those are calculated, things can quickly unravel at that point. Again, sorry, just on that point, just on the due diligence, if a decent job has been done of the due diligence, that should feed into this and minimise any ambiguity at this point. Sorry, Alex.
Oh, sorry for interrupting, Holly. I was just going to just add some a bit of meat to what Holly was referring to there, which is about seasonality in the business, specifically on the timing. If the business has specific seasonality or wide fluctuations in seasonality, that can significantly impact the value received post completion or at completion due to the normalization of working capital and how that is estimated as at completion.
So moving on to earn-outs and contingent consideration. So this is probably where we see, we see a lot of disputes around the earn-out. So, both of these are about dealing with uncertainty over the future, protecting the buyer, incentivizing the vendor. And I think the key point here is that obviously after the transaction, the vendor loses control and the buyer will have different ways of doing things. The vendor may still be working in the business, but they'll have different ways of doing things, and their actions may affect the earn-out and contingent consideration in a way that the vendor may not have anticipated. And as is often the case, the vendor, this will be their only sale. They've never been through this process before. So anticipating, having the foresight, and anticipating what might happen and what the changes could be within that earn-out calculation can be quite difficult, which is why obviously they need good advisors. And you may have an accountant on the transaction. Hopefully in most transactions you will have a decent corporate finance advisor and a decent corporate lawyer, but that's not necessarily the case, as some businesses use accountants which may not be familiar with dealing with transactions. So it's anticipating that and detailing in the earn-out and modelling what the impact could be of different changes. But it's quite often the provisions there are a high level or too high level, not detailed enough to foresee and anticipate the scenario that pans out, and then hence we find ourselves in a dispute scenario.
So I guess that's over to me. Dispute scenario. So I tend to get involved doing expert determinations when there are SPAs that result in disputes because people don't agree the completion accounts or the earn-out statements. And one of the key issues is the nature or the identity of the person who prepares those documents. So in most deals, it's the buyer that initially prepares the documentation for the completion accounts or the earn-out statement, and then the seller has the opportunity either to agree the figures or to dispute them. But one of the key provisions that is often missing from SPAs in my experience is the provision that allows the seller access to the books and records of the business post-completion. And all too often I see cases where there's a dispute, but what the seller says is, well, it's not fair because I can't get access to the core underlying documentation, and it's not just the accounts that they need access to or the management accounts. It's often the prime accounting records that the seller needs to have access to in order to work out whether the earn-out statements, the completion accounts, whatever they are, have been prepared fairly and properly. So I would urge you, when you're drafting SPAs, make sure that you include a provision, if you act for sellers, that they have an absolute right to whatever information they need post-completion for the purposes of assessing the accuracy and validity of any documentation such as completion accounts that may be prepared. But taking a step back, what we are looking at here is the provision within the SPA, and if all goes well, you'll all be familiar with these terms, I'm sure. What happens is that there's a review period, and the buyer has the opportunity or typically it's the buyer that does do the preparing. So the buyer serves a written notice on the seller, confirming agreement with the documents, and then everything is fine. The documents are agreed, and as it says here, they shall be final and binding on the parties. And then you see the last word on this slide is the most important, or the alternative is that there may be a dispute. And if there's a dispute, you will get a dispute notice. Most SPAs include in the dispute notice a resolution period during which it's possible for the buyer and the seller to reach a resolution. And if that resolution is reached, then once again, you've got a final and binding agreement between the parties. But then once again, you see at the bottom right-hand corner of the slide, the key word or. So if you've neither got agreement from the outset, nor have you managed to get agreement in the resolution period, what happens there next? Well, if not resolved by the parties after the resolution period, then you end up with no alternative but to come to somebody like me for an expert determination. And that is really what the rest of this talk is going to focus on. So we're going to talk about expert determinations, the key feature of which is that they are final and binding, but for fraud or manifest error. There was one case I dealt with where the one of the parties said that the other party was such a snake that no matter what the expert determined, there would inevitably be a further wrangling and argument. So they took out of the agreement when they drafted the SPA the words manifest error. So it said that the expert determination would be final and binding save for fraud. They then rued that day because the expert determination came out very much in the other person's favour. They wanted to try and get out of it. There were umpteen manifest errors in the determination, but there was nothing they could do. In fact, they went to their solicitors and it was a local case, and they said, is there any way you can get us out of this? And the solicitors said, well, confided in me, they said, we're in a difficult position here. We were told to make this absolutely watertight and to make sure there was no way that anybody could argue that this wasn't final or binding save for fraud. And there's certainly no suggestion of fraud. There's just lots of errors. If we manage to get our client out of the pickle, we'll have proved that we were incapable of drafting an agreement that was watertight. But on the other hand, if we're as good as we think we were and we have made this watertight, our client will be stuck with a determination that is horribly wrong and full of errors. That nature. That final and binding nature was confirmed in a case called Premier Telecoms, and it is very clear that the courts are incredibly reluctant to allow people to challenge expert determinations, even when there are errors. The judge said in that case that parties who refer a matter to an expert for a decision usually do so in order to obtain a quick and relatively inexpensive decision of a binding nature on a matter that calls for informed judgment, and must, the judge said, be taken to have recognized that mistakes may be made, both of fact and law, but they're prepared to take that risk because they place a high degree of confidence in their chosen expert. And I think what that highlights is that it is really important to make sure that you choose the right expert. I spoke to one FD who rued the day when he had managed to persuade the firm that was instructed, it was a well-known international firm of accountants that was instructed to undertake an expert determination. And he had managed to bash them down to agree to a bargain basement price. The problem was that they then delegated the work of the determination to very junior staff. They didn't give it the care and attention that it deserved. And as a result, they got a determination which, as I say, was full of errors. Whether they were manifest or not is an interesting question. And the definition of what is the difference between an ordinary error and a manifest error is definitely a matter for lawyers and not accountants. But there were some pretty blatant howlers in this determination, which probably wouldn't have been made if the fee they'd paid had been higher and justified a bit more partner involvement. So I think the message to take home is that there are great advantages to expert determination clauses because they do enable disputes to be resolved relatively cheaply and relatively quickly compared with court. But once you have a binding determination, it's quite hard to go behind it. Having said that, I was in court last week in Cardiff dealing with a case where there has been a determination, and one of the parties was saying that not so much that it should be set aside, but was then making various claims for breach of warranty. And it will be interesting to see how the court deals with that, because as I say, the courts have traditionally been very reluctant to get involved where there's been a determination. But in this case, there are suggestions that whilst the deal that was done was in accordance with the SPA, that there's been a determination that there were nevertheless very significant breaches of warranty that justify looking behind it. So going back to the point about the importance of getting the right expert, when you're drafting expert determination clauses, often it says that the expert shall be agreed between the parties, or in the absence of an agreement, the expert shall be chosen by the president, whosoever it be, at the time of the Institute of Chartered Accountants in England and Wales. And as a fellow of the Institute of Chartered Accountants in England and Wales, I was traditionally very proud of the fact that it said that it was the ICAEW president that should be the person that nominated experts, and not the president of one of the other accounting institutes, the ACCA or whatever. But as it happens, the ICAEW absolutely hates this scheme, and they have been doing in the last few years everything they can to discourage people from using it, and it makes me weep as a fellow of the institute that they don't celebrate the fact that it's the ICAEW that is quoted in the vast majority of these types of clauses. The reason they hate it is that they've never worked out how they can decide who goes on the list of people from which they nominate potential candidates, and who should be debarred. And there are qualifications that one can take in expert determination, and one would have thought that that would be a good place to start. But they hate the idea of grandfathering in people in, and the most senior partners of the Big Four don't want to take exams to prove that they're capable of doing things that they've been doing for years. And the Institute ties itself up in absolute knots. But the problem is that the president appointments, because they allow anybody on the list, often result in people who don't have the relevant expertise being asked to undertake determinations. They then go horribly wrong, and then it goes back to the institute that gets criticised for putting forward the wrong people, and they hate having that responsibility. So now you will find that the institute will charge you a princely sum of, I think it's about £10,000 just to come up with a name, and the name may well be from a random list of people that is pretty ill thought out. So that raises the question as to who is the right person to nominate an expert in the absence of agreement between the parties. And I think perhaps there is scope. There's no obvious alternative, because I don't think the ACA would be any more keen to do it than the ICAEW. But the other thing to recognise is that even if you get that nomination, and of course it's only the most bitter disputes where the parties can't even agree who the expert's going to be to determine the issues in dispute. If they can't even agree on the expert, they're not going to be able to agree on much. And what has happened in a number of cases is that whilst the president, if you pay your £10,000, will give you a very fine certificate which says that Mr. Bloggs has, or Mrs. Bloggs has been appointed as the expert to determine this dispute, it isn't really an appointment in any genuine sense. It's a nomination. And by that I mean that until or unless the parties have both signed the letter of engagement that will be issued by whichever expert has been nominated, the matter can't proceed. So it's really important to make sure that when you're drafting an SPA, you try, if you can, to include clauses that enable, where you can, that thinks about what's going to happen if one party refuses to sign the letter of engagement that's issued by the expert. So, as I say, you need to bear in mind it's a nomination, not an appointment. You need to make sure that you don't negotiate a fee that is too low, because that can come and bite you. And you need to deal with the issue of non-engagement. And non-engagement is not only a problem at the early stage. So ultimately, if one party just refuses to sign the engagement terms, it is possible to make an application to court, and this has certainly happened on more than one occasion, and then the court will effectively sign the letter of engagement on behalf of the party that isn't engaging. And if you put a clause in to the SPA that provides for that, it will make it that much clearer to the parties that that's what's going to happen, and they can't just simply not engage in the process. But non-engagement can also be a problem further down the line. If one party just refuses to engage, you need to work out how to deal with that. And one way is to include, either explicitly in the SPA or in the terms of engagement of the expert, a clause that says that in the event that one party fails to respond to questions, say, by the expert shall be entitled to draw adverse inferences from that absence of information. And I think that's quite a useful clause to include. But on the subject of process, be aware that there are now standard rules. They exist on the Academy of Experts website and on the ICAEW website. You'll notice that the Academy's rules look very similar to the Institute's rules. That's not a coincidence. There was a lot of collaboration between those two organizations, and often referring to these rules, I think, in an SPA is a good idea. So it can say whichever expert is appointed, unless the parties agree to the contrary, they will adopt the standard rules for expert determination as published by the ICAEW. And again, the more you can think about this sort of stuff early on when you're drafting SPAs, the less room there is for argument and delay later in the day. Those rules will deal with things like the number of submissions. So the sorts of things, and again, you can think about this and agree this and specify it in the SPA. Sometimes it's appropriate for both the buyer and the seller to simultaneously exchange their submissions. But it can sometimes be better if one party makes submissions, the other party responds to those submissions, and then typically the party that made the initial submissions should have an opportunity to comment on the reply, and then finally there's one more opportunity for the party that went second to have the last word and make a response to those comments. So you end up effectively with each party having 2 rounds of submissions and each having an opportunity to respond to what the other has said. The advantage of simultaneous submissions is that it makes the process shorter. I mean, if you think about it, if you allow 21, 28 days for each round, if you're going to have 4 rounds of submissions, often the later rounds can have shorter timetables than the earlier rounds, but you can quite easily get to a period of many months, which in my experience is not at all unusual in these sorts of circumstances. But again, when you're drafting SPAs, think about whether you want to adopt the standard rules. What do those standard rules say about the number of submissions? Are you going to provide, as I think is probably helpful, because the more you put in the SPA, the more is agreed, the less scope there is for argument afterwards. Are you going to have 1 round or 2? Are they going to be simultaneous or sequential? And then do think about the timetable, because often I see in SPAs timetables that are completely unrealistic. What they typically say is there'll be a dispute notice, an expert will be nominated within a couple of weeks, and then in a couple of weeks the expert will give the determination. That just never happens in practice. What happens is that it takes quite a while to agree who the expert's going to be. The expert will then ask for information. The expert will then give quotations. Sometimes there might be 2 or 3 experts that are approached. Each will give quotations. The parties will then decide which expert they want to go with. You then have to agree the procedure. You then have to agree the terms of engagement. Even that can take 4, 6, 8 weeks. And then you start the process of submissions. Certainly, if parties are going to instruct accountants and lawyers to help with their submissions, they're going to need at least a month, possibly 2, to put those submissions together. Those submissions, if you're going for sequential exchange, will go to the other side. They will need to consult with their lawyers, with their accountants, to put together a response. Sometimes counsel is involved. So the whole process will take, with the best will in the world, several months. And typically, whilst parties, when they're drafting an SPA, may have a desire that any dispute is resolved within milliseconds, the reality is that putting unrealistic timetables in the SPA helps nobody. So I would urge anybody drafting an SPA to give sensible thought to how long this stuff really takes. And the answer is it takes a long time. One of the other things to think about is whether you want that determination to be speaking or not, by which I mean, is the expert going to give the reasons for the determination or not? Now, if you go for a non-speaking determination, you may end up spending a 5-figure sum for a 1-page bit of paper, which says, I, the expert, determined that the answer is 42 or whatever it might be. And the parties may feel that that's pretty unhelpful and poor value for money. The reason why a non-speaking determination is sometimes a good thing is that it is almost impossible to challenge. So if you really, really want certainty, a non-speaking determination will bring you more finality than you will get with a speaking determination. Because, of course, if the expert gives detailed reasons for his or her determination, there is always the opportunity to try to spot manifest errors. I mean, I remember once I sent out a determination and I got a reply immediately back and said, thank you so much for your determination. We will review it now to see if there are any manifest errors in it, which is an uncomfortable position for any professional to be in. We don't normally send out tax returns to our clients and get them replying saying, thank you for the tax return. I'm going to review it and see if you've made a manifest error. One of the reasons why this work is the riskiest work that we do is that the only option realistically to challenge an expert's determination is to allege manifest error, which is not something that any, as I say, any professional likes. And if they are challenged, it is for manifest error because that is the only option available. So again, there's nothing to stop you in the SPA saying that the matter will be referred to an expert for determination, and the expert's determination should be finding and binding and be given with or without reasons. And one other thing that I've never actually seen, but I often advise ought to be considered in a sale and purchase agreement, or even subsequently in the event of a dispute, is the use of caps and collars. Now, what I mean by caps and collars is this. Often you find that people are nervous about an expert determination because they worry that it's possible that an outlandish answer will be derived. So in the Premier Telecoms case, that was a determination that didn't arise from an SPA. It was simply a shareholder disagreement, and that was a 40% shareholder and a 60% shareholder. And it was agreed between the two of them that the 60% shareholder would buy out the 40% shareholder, and that the price that the 60% shareholder would pay would be the matter of expert determination. And the 60% shareholder was expecting to pay on a good day £500,000 and on a bad day £1 million for the 40% shareholders' shares. So you can imagine how he felt when the expert valued the shares at £4.5 million, 9 times the lower estimate, 4.5 times the upper estimate of what he thought was reasonable. And I think in those sorts of determinations, if you are drafting agreements that deal with matters that are potentially uncapped, it is quite sensible that if one party has a view as to, say, what the value of the shares are, and that differs from the other party's view, that you say if the expert values the shares at more than X, then the price that will be paid will be whatever the person who wants the high price has said at the outset it should be. And similarly, if the valuer, the expert values the shares at lower than the bottom end of the range, the value, the price offered by the person who's arguing for a low value, then it will have that collar. The price will be set at the bottom end of the range, and that mitigates the risk for both parties. Admittedly, it means that nobody gets an absolute bargain or has to pay an absolute fortune. But again, I think in the context of those sorts of expert determinations, it's helpful to give some thought to whether a cap and a collar is appropriate. And then often there are terms in the expert determination clause that says the expert shall be entitled to determine costs. But often the word costs isn't defined. So the question is, are these just the costs of the expert's fees? Often, as I say, each party will employ lawyers and often accountants and sometimes counsel too to advise on the submissions. So if you are drafting a clause which says that the expert shall, at the end of the determination, determine where the costs of the determination should fall, make sure you define whether the costs of the determination are just the expert's costs or both the expert's costs and the costs that the parties have incurred themselves on getting professional advice in relation to the determination. And finally, if the result of this determination is that money is going to be paid by one person to another person, give some thought to whether there should be also a determination as to issues about time to pay, and then each party can make submissions if appropriate, because often there's quite ambiguity. So a value might be assessed by the expert determiner, but how that value converts into cash, what the time to pay is often missed out. So it is now 1:45. We said we would speak for 45 minutes and then we would open the floor to questions. We had a couple of questions that were submitted, I think, in advance. I think, sure, I've probably dealt with those, or at least I'd like to think I have. But have there any other questions come in while we've been speaking?
So I think you have covered off the ones that were submitted. I haven't had any more that have been put through into the Q&A box. Let me just, and there's nothing in the chat box either. Guys, if you do have any questions, please do feel free to put those in there. What I'll do in the meantime, just to give you an opportunity to put those forward, is just to briefly go through the 3 that we had in advance and just see if anybody on our panel would like to add anything specific to those questions, even though, like I say, we think they've probably been covered during the course of the talk. So the first is, how can expert determination clauses be drafted to ensure fairness and enforceability for all parties? Are there any sort of bullet point summaries that you would give in response to that question?
Well, as I say, I think that's really been the subject of the talk. So hopefully I will have covered that. Is there anything, Hollie, Alex, you'd like to add? I think that's a no.
No, absolutely. Okay, the second question then was, how do you ensure objectivity and fairness in expert determination where one party has contributed more heavily to the data or documentation submitted? Is there growing preference for speaking or non-speaking determinations in such scenarios? Again, that's all been covered very well by what you said already, I think. But if there's anything that anybody on the panel would like to add on that specific point.
I mean, certainly the point about which parties contributed more heavily. I mean, that speaks to two of the things I mentioned. One is engagement. What do you do if one party is not engaged? And secondly, what do you do if one party just can't get access to the document? So the message is make sure that the SPA provides that parties are both able to get access to prime accounting records, and that the expert is entitled to draw adverse inferences if one party doesn't engage. I think that's the answer to the first bit. And as for speaking or non-speaking, I think most people want speaking determinations simply because they want that there is an obvious wish for clarity and curiosity. If they're fighting a case, just simply to get a one page which says the answer is X without having any idea how that number was calculated can be quite frustrating, even for the so-called winning party. Alex, you've unmuted. Were you going to say something?
No, I think you covered that well.
Cool.
And the third and final one that we had in advance, actually says, yeah, could you please suggest appropriate wording for a clause appointing an expert to act in the case of a dispute? I think that's probably beyond the remit of this talk. It is quite an opportunistic grab for some wording to save yourself some drafting there, I think, whoever submitted that. So I think perhaps we'll leave that for now, but do take away from the talk some of the suggestions that Roger's covered throughout the course of it, because that will help inform your drafting, having a better understanding. In the meantime, we've had one new question come in, which says costs provisions will often provide that costs of the expert will be split equally unless the expert otherwise directs. And it says, in your experience, does an expert ever take up the opportunity to shift that one way or the other?
Yeah, I do. Definitely. I have often made apportion costs heavily towards one side or another, where it's clear that one side has genuinely put forward submissions that I side with. And where one party I've rejected their submissions, often they also have to bear the cost consequences. I mean, it can be. I was looking at a case recently involving revenue recognition and deferred income, which is the sort of thing that accountants love to get involved with, and often is a matter of dispute. And there was an argument in this case as to how deferred income should work. One party said that when an invoice came in, it should be spread evenly over the year. The other party said that what they were doing was recognizing 2/3 of the income in the amount of in the first month in which the invoice was raised, because they said that was the month when most of the work was done, and the balance was spread equally over the course of the year. And in fact, this argument about how deferred income should be treated had gone on for well over a year. And it went to determination. But actually, it turned out that one of the sides, contrary to what they were arguing, had actually, in their calculation, put in tens of thousands of pounds of just fudge factor, which didn't comply with the policy they were advocating whatsoever. And I think if you discover something like that, it's entirely reasonable to put adverse cost consequences on somebody who has acted in a way that their submission, you found that their submissions are utterly unsupportable or unsupported. So yes, I don't see why you shouldn't allow an expert to make those sorts of cost decisions.
Great, thank you very much. Well, we've had no other questions come in here, so unless anybody's going to very quickly type one in, I think
I'm sure lunch needs to be bought and dogs need to be walked. The sun's shining here, so the window of opportunity may be small, but now's the time to grab it.
Fantastic. Well, on behalf of the Society and all those attending, thank you ever so much for your talk and the preparation put into it, and all the information you shared with us today. That's been great.
You're welcome.
And we shall leave the rest of you to depart and get back to your working days.
All the best. Bye, everyone.
Thank you.